Thanks for joining us for this second instalment of our three-part series on the Third Parties Rights Against Insurers Act 2010. That being quite a mouthful, we'll be calling it the 2010 Act. My name's Alex Marler, a partner in the insurance team here at Waitmans, and I'm again joined by fellow partners Rob Crossingham and Richard Palmer. So in the previous session, we looked at the current economic landscape and how it might drive claims against insurers under the 2010 Act. Today, we're going to run through what the Act actually does and what it doesn't do. There's still been some misconceptions about that. Now, firstly, and with no wish to turn this into a history podcast, I think that to understand the 2010 Act, it's useful to know why it was enacted and the central premise of what it's intended to do. The 2010 Act came into force in 2016, and it replaced a 1930 Act of the same name. Now, the 1930 Act addressed a fundamental unfairness prior to that time in how insurance proceeds were treated in an insolvency situation. Before then, if a defendant facing a claim went bust, a policy could still in principle pay out, but the proceeds would not go to the claimant. They instead went into the general pot with whatever other assets the defendant might have, and those assets would then be distributed amongst creditors generally according to the normal rules of insolvency. So in practice, of course, that meant that a claimant would see often little, if anything, of the payout from insurance that was intended to cover claims of just the kind that they had brought against the insolvent business. So they could be claims of a professional negligence kind, EL, PL, whatever. And a claimant couldn't sue insurers directly as there was no contract between them. That situation was seen as fundamentally wrong and unfair, so the 1930 Act was brought in to address it. Effectively, it ring-fenced the proceeds of relevant insurance for the benefit of those with valid claims against an insolvent defendant, and gave claimants the right to sue insurers direct. So from then on, the claimant could sue the insolvent defendant, and if and when they got judgment, could then claim directly against the insurer, getting at the cover under the policy rather than that payout being distributed amongst all creditors. So the 1930 Act was a step forward, but it had problems. The main shortfalls were that it was still necessary for the claimant to start by suing the insolvent company, getting judgment against it before it could claim against the insurers. And that was a burden in terms of time and money, especially if the defendant company had been dissolved and so would need to be restored to the register of companies. And the main other issue for claimants or prospective claimants was the inherent imbalance of information. It could be difficult for a prospective claimant to know whether it was actually worth spending the time and money on a claim, as there was no real way to find out whether there was relevant insurance in place behind the proposed defendant, and even if so, whether it was actually likely to pay out. And it wasn't perfect for insurers either. And Richard, I think you had a couple of points on that.
Yeah, Alex, I think one of the issues for insurers was that until a judgment had been obtained against insurers under the 1930 Act, they had no or very little control over the defence of the underlying claim, and they'd not be able to defend it in the same way that they could if the claim was made against a solvent policyholder of theirs. Where an insurer had a very strong policy defence, it could afford to take a robust attitude and leave the insured to defend the third-party claim unaided. It could feel confident that if the third-party claimant did obtain a judgment against the insured and then proceeded against the insurer under the 1930 Act, it would be successful in establishing its policy defence. Where, however, the policy defences were more questionable or where more information was required to make those decisions, it would generally be prudent for insurers to try and retain some degree of control or guidance over the defence of the third-party claim. And the advantage of doing that would be to minimise the damages in case the policy defence is proved unsuccessful. The disadvantage was that knowledge of the insurer's involvement might have encouraged the claimant to proceed with its claim, whereas it might not otherwise have done so, given the surrounding uncertainty of the insolvency event. So it's very much a balancing act, taking into account such factors as whether the insured was able and willing to defend the claim itself, whether there were in fact available defences to the claim, for example, as to liability and quantification of damages, and whether there were other reasons for ensuring that the claim was properly defended, for example, to prevent other losses suffered by the claimant from being wrongly attributed to the insured. So that was sort of effectively, from insurers' perspective, what were the issues there. So, Rob, perhaps you can sort of tell us how we then get to the 2010 Act.
Yeah, sure. Well, we eventually got the 2010 Act, and I say eventually because there was quite a long delay between it being enacted through Parliament and being brought into force in 2015. But we got it in the end, and it was intended to address all of those issues. So what does the 2010 Act do? Well, in short, it provides a mechanism for a claimant to, firstly, obtain information regarding an insolvent defendant's insurance position. And secondly, it enables a claimant to pursue that defendant's insurers direct without first needing to establish the insurer's liability. That in itself removes the quandary that insurers found themselves in, as Richard described. They now have the opportunity to get involved directly at an early stage. In other words, they gain control of the situation to a degree. For the time being, looking just at the right to information that potential claimants get under the 2010 Act, I'll address what information can be obtained, from whom, and how. Firstly, what information can be obtained under the Act? Well, a claimant can now seek certain information regarding relevant insurance. Essentially, is there a relevant policy of insurance, with whom and on what terms? Have the insurers purported to decline? Has there been any litigation regarding a purported declinature? If there's an aggregate limit of indemnity, how much is left? And is there a fixed charge that would apply to any payout? That information that's required to be disclosed is set out in Schedule 1 of the Act. So although it doesn't amount to a hugely extensive disclosure, we can see that these are just the sorts of things that a prospective claimant would like to know to start to consider whether it's worth bringing a claim against an insolvent insured. The second part is from whom can the information be obtained? An important question from a practical point of view. Here, the 2010 Act is extremely wide. Information can be sought from essentially anyone who the claimant reasonably believes might have it. The Act refers to a person who is able to provide the information. Most obvious candidates are the insurer itself, as the claimant knows or suspects who that might be, the insured in the form of an administrator or liquidator, brokers, former directors or employees of the insured. The third part of the procedure is how does the prospective claimant go about obtaining this information? The claimant needs to make a written request for information under the Act, give notice effectively, setting out the information requested and the particulars of the facts relied on as the entitlement to give notice. Having received a notice, the respondent must, within 28 days, respond to the claimant, providing it with the information requested, or if they don't have the information, explaining why not. In the case of information that the responding party once had but no longer has, it must outline the information who it believes now has that information. In terms of enforcement, if the responding party does not respond to provide the information expected or can't explain why they don't have it, the claimant could then apply to the court for an order that they do so. It seems to me that if they're found unreasonably to have withheld information, they might be exposed to adverse costs. Alex, I think you were going to expand on the extent of the information required to be disclosed under the Act.
Yes, thanks, Rob. I think the first point to remind ourselves of is that the requirement, I'll start that again, put my teeth in. I think the first point to remind ourselves of is that the requirement is to provide information, not documents. We still see some misconceptions about that, with some quite muddled demands for disclosure being made by claimants. And the list of information that must be provided is prescriptive and specific. It's not a license for a general fishing expedition or please tell us everything we might like to know about the insurance position generally. And we'll discuss some of the strategic points about that in our third and final instalment, when we'll be looking at the question of how to deal with requests for information under the Act and claims arising. So the Act provides a clear mechanism with quite wide-ranging scope for a claimant to seek information to make an informed decision about whether it's likely to be worth going after an insolvent defendant's insurers. Now, let's imagine that a claimant has gone through that process and the information obtained leads it to conclude that it's worth going after the insurers. What's the procedure? How does it work? Are there any limitations? Firstly, the core premise of the Act is that the claimant may now bring a claim directly against the insurers without first needing to establish the insured defendant's liability and without restoring it to the register if it's been dissolved. So there's no longer a requirement to get judgment against the defendant itself. They go straight at the insurers. That being the case, in such a claim against the insurers, the court's going to be dealing with two issues. There are two hurdles for the claimant to get over. Firstly, the liability of the insured defendant. So in the usual way, the court will be looking at duty, breach, causation, quantum. Secondly, there will be a decision on the insurer's liability to provide an indemnity for any loss that is established under that first limb, a declaration as to the requirement to indemnify. So those two hurdles are nowadays to be dealt with in one set of proceedings, but of course the claimant has to overcome both the hurdles if they are actually to get any money out of the insurers. So we can see how it might seem that the 2010 Act imposes quite a burden on insurers in terms of responding to requests for information in the first place, and also exposing them to claims that might otherwise not have been made. Under the old regime, as we mentioned, it was hard for a claimant to establish whether it was worth bringing such a claim. Now it's easier. And so a claimant can form a view and decide to bring a claim directly against insurers. But there are also benefits for insurers. And Richard, you flagged up the issues for insurers under the old 1930 Act. So perhaps I can turn back to you to outline the benefits of the new Act for insurers.
Of course, no problem. I think in my view, there are two key advantages for insurers under the 2010 Act. First, the response to a request for information can, in appropriate cases, be used to explain to the claimant why the policy isn't going to respond, whatever the ultimate finding on the insured's liability. And then secondly, if a claim is brought, then from the outset, the insurers can deal with both the insured's liability and also raise any coverage points. They can get stuck into both arguments and neither one will prejudice the other. So for example, by getting into the arguments on the insured's liability, the insurers are not taking to be accepting that the cover responds. So we can see how this may be better than the old 1930 Act situation, as I mentioned earlier, where a claim against the insolvent insured might well not be effectively defended. This would result in a judgment, which the claimant could then use against the insurers who, through no fault of their own, would have missed the chance to raise arguments on the insured's liability.
Thanks, Richard. So with that outline of the essential aims and provisions of the 2010 Act, what it does, the pros and cons for prospective claimants and insurers as defendants, what are some of the areas in which there is still debate and potential dispute? Crucially, the core premise is that the indemnity to which the claimant will be entitled under a relevant policy will be only as good as the indemnity to which the insured defendant would have been entitled under what was then its own policy. So generally speaking, the usual coverage defences will be available. Did the insured give fair presentation? Has it breached any conditions of its policy? There are still grounds for potentially declining cover and avoiding payout liability by the insurers, even where the liability of the insured is established. And insurers also have a right of set-off. If the insured owed them money before it went bust, that will be set off from any payout that the insurers have to make to the claimant. And the most obvious thing would be unpaid premium. Also, of course, insurers still do not have to pay any excess that applies under the policy. The claimant will simply not get that unless there is any assets left with the insolvent defendant itself. But the Act does give claimants some leeway in a couple of coverage areas. Firstly, the Act renders void any provision in the insurance contract that purports to terminate or alter the contract due to the insured going bust. So clearly, without that, the entire purpose and effect of the Act could have been neutralised by a few words in the policy, and words that an insured probably wouldn't object to when looking for cover, because they wouldn't be particularly concerned about what happened in the event of them having gone bust. And Section 9 of the Act sets out a couple of other limitations on insurers' rights in respect to the cover. Firstly, the claimant can now take any steps that the defendant, the insured, should have taken to comply with the policy. And an obvious example would be notifying the defendant's insurers of a claim or circumstance, as is pretty much always required under policies. And the ability that claimants now have to find out the terms of cover mean that they will be better placed to identify the requirements that were placed on the insured under that policy, and to take steps to take them itself if it seems that the insured didn't take them, and so protect the cover. Now, policies also invariably contain a condition requiring the insured to provide insurers with information, cooperation, and assistance in the defence of claims. Under the 2010 Act, insurers have no remedy for a breach of such a condition, but only where the insolvent insured has died, if they're an individual, or has been dissolved where it's a company. The mere insolvency isn't enough. That claims cooperation condition would still be effective. But where it's been dissolved, that claims cooperation condition is now nullified, because obviously it again would make a nonsense and deprive the claimant of the benefit of the Act if that could be invoked. Pay to be paid clauses in the insurance contract will also be void. The insurers can't insist that the insolvent insured pay out a claim before the insurance will indemnify. Again, clearly that wouldn't make sense. So these restrictions are intended to prevent the Act being rendered toothless by insurers demanding compliance in ways that aren't feasible following an insolvency. So far, we've been talking mainly about the 2010 Act in litigation. Richard, we were discussing how it works in terms of other forums for dispute resolution. What's the position, for example, with arbitration?
Well, the 2010 Act does cover arbitration where that is applicable. In other words, where there's an arbitration clause in the insurance contract or appointment document. Section 1.4 of the Act provides that for the purposes of the Act, a liability is established only if its existence and amount are established. And the ways to establish and quantify the insured's liability for the purposes of that enforcement under Section 1.4 are judgment, arbitration award, settlement, or by simply asking the court for a declaration under Section 2. And a declaration will be to the effect of the insured's liability and the insurer's potential liability to the claimant.
Thanks, Richard. And Rob, what if the claimant succeeds against insurers in a claim under the 2010 Act, but there's a shortfall, a limit of indemnity lower than the damages award, or say a big excess? Is there anything the claimant can do to try and recover that shortfall?
Yes, there is. The claimant can still pursue the insolvent insured for a shortfall. I guess the financial situation of the insured's insolvency will dictate whether or not it's actually worth a claimant doing that, and it often won't be unless there's a decent amount left in the insolvency or a particularly large shortfall. There might be claims against the insured's directors in some cases, and we spoke about that in the context of the FCA. Where, for instance, a policy might have been avoided for fraud or wrongful trading was involved. Of course, the claimant can also carry on claims against any other defendants it holds jointly liable to try to make up the shortfall. There might, I suppose, also in the background be other insurers who could be pursued. If the claimant is only pursuing PI, maybe they could pursue DNA, maybe they could pursue PL as well. But their options are a little bit limited if there's a shortfall on the policy that they're pursuing.
Thanks, Rob. And Richard, where does the Act apply? Is it only England and Wales? And what about reinsurance? Does it apply to those contracts too?
The Act applies not just in England and Wales, but to the whole of the UK. There are some additional provisions specific to Northern Ireland and Scotland, but the overall effect of the Act is substantially the same. And no, it does not apply to reinsurance contracts.
Thanks, Richard. That's helpful to outline the scope of the Act. Rob, what about limitation? Any special provisions under the Act in that regard?
I think it's much as you'd expect, really. Limitation applies as normal in terms of the insured's breach or the loss caused by it, so generally 6 years or 12 under a deed. Note, though, there is a slight wrinkle if the proceedings are brought against an insured in time and it then goes bust. Those proceedings get a foot in the door for a claim against insurers under the Act. So there's a little nuance there, which is probably less likely to arise, won't be the normal course of events. So nothing out of the ordinary, really, Alex.
Thanks, Rob. And that brings us to the end of today's session. We've looked at the issues the 2010 Act was intended to address, its key provisions to achieve that, and some of the nuances and ins and outs. In our next session, we'll look at some strategic considerations when responding to requests for information and defending claims against insurers under the Act, as well as looking at using the Act to pursue subrogated claims against the insurers of third parties. I hope you can join us for that.